Well, good evening, everyone. I'm Kurt Beckett. I'm chair of the Energy Facility Site Evaluation Council, the Washington Energy Facility Site Evaluation Council. Let me get, I guess, my other document here. Sorry, a busy day. I'm going to call this meeting to order at 5:32 p.m. And just a couple opening remarks, and then we will officially further kind of gavel in and call our roll for our FSEC Council and do a few introductions. So again, welcome. For those of you who are here in person tonight, we certainly appreciate you joining us, and certainly appreciate those who are online, both other council and staff members, and most importantly, other members of the public. We'll begin this evening with the public informational meeting as required by state law. And the purpose of this meeting is to provide an overview of both the FSEC review process, followed by a little deeper overview of the Cascade Renewable Transmission Project. We will then receive any public comments from both our in-room and online attendees on issues and questions that you believe should be included in the FSEC project review. The second meeting, which will begin after, obviously, the first project informational meeting ends, and that is specifically about land use consistency. We will have Judge Russell Miko joining us for that portion, which we'll speak to more once we get there. And with that, let me further call this order to order, and if Ms. Grantham would please call the FSEC Council roll.
Certainly, Chair. Department of Commerce.
Will be absent tonight.
Department of Ecology.
Blake Nelson, present.
Department of Fish and Wildlife.
Nate Pamplin, present and participating virtually.
Department of Natural Resources.
Maverick Ryan, present, participating virtually.
Utilities and Transportation Commission.
Brian Ryberick, present and participating virtually.
Assistant Attorney General John Thompson.
I'm present online.
Administrative Law Judge Russell Mikow.
I'm present online.
For council staff here today, Sonia Bumpus.
I'm present online.
Amy Hofgemeyer.
Present.
Lance Caputo.
Present.
Carl Holapa.
Present.
Maria Belkina.
Present.
And Lisa McLean.
Online.
And do we have anyone present for the Council for the Environment?
Yuri Karol, present, appearing online.
Thank you, Chair. There is a quorum.
Thank you very much. Let me next do a couple additional introductions, and if I could give our Council for the Environment a quick heads up that when I'm done with a couple of these, I would turn this back to you for a brief word on the role of the Council of Environment. And first, let me recognize our colleague from Oregon, Chris Clark, who is also with FSEC of Oregon, which is housed within the Department of Energy of that state. One key distinction is Washington, like with kind of two V's, we have two E's, and Oregon is the FSEC with one E. So a quick way to think about that. And this is ultimately a joint project. We're focusing on the Washington side of these issues tonight. And with that, let me also ask if our applicants would go ahead and introduce their team, and then we'll move to the FSEC staff and soon into presentation.
Sure, thank you. I'm Chris Hocker with the lead developer PowerBridge, my colleague Susan Brown, and there are a few others in the audience associated with the project who hopefully some of you have been talking to already, and certainly any questions like that you might have, someone can answer.
Thank you. Let me go ahead and actually back to Council for the Environment so we can make sure everyone understands the role of that role for the people of Washington. Council?
Hello, everyone. My name is Yuri Karol. I'm an Assistant Attorney General with the Environmental Protection Division. I have been appointed Council for the Environment for this particular project, and in my role, which is statutory in nature, my job is to represent the public and its interest in protecting the quality of the environment. So in practice, that means I can submit comments. I'm also a party participant in any adjudications, should there be any. I will be looking at the environmental impacts of this project on my own, but I also encourage public participation. So if you feel like you have any information that I should be aware of or should consider, please feel free to send them my way. My name and contact information is on the project-specific website on the FSEC website, and I can also drop them in the chat for this meeting. Yeah, I think that sufficiently covers it. If you have any questions, please let me know.
Thank you, Council. All right, with that, let me turn this to our FSEC staff, starting with our Director, Sonia Bumpus, for any opening remarks, and then we'll move to our PowerPoint overview of the FSEC process.
Chair Beckett, again, I'm sounding clear.
I think we've got you now, but if it starts to fade, I might note to douse your camera, but we've got you so far.
Okay. Yeah, just let me know. I think there is a lag. So I just wanted to make a few remarks before we begin the presentation by staff. My name is Sonia Bumpus. I am the Executive Director of the Energy Facility Site Evaluation Council Agency. I want to welcome you this evening and thank you. It means a lot to us. We know everybody is.
Director Bumpus, it is starting to fade out. Perhaps it may be on our end, but why don't you try your camera and then we'll see how that goes. And otherwise we can turn to Ms. Hoffagemeyer. All right. Let's pause on that. And Amy, I'm going to start, and if you want to supplement some
busy these days.
Director Bumpus, I think we're going to toggle into the room here and see if Amy can. The world we live in. All right, Director Bumpus, I'm going to turn here to Ms. Hoffagemeyer, and I think ultimately what Director Bumpus was trying to make sure and help convey is where we're at in the process, which is certainly the beginning. There are many aspects of things that need to happen on the front end, some of which are a work in progress, and many others still to come. So with that, Amy, if I can pitch this to you.
Of course, thank you. So thank you for joining us this evening. We're here really to introduce ourselves as an agency, introduce the project that is now in front of us along with the applicant. And what we'd like to do tonight is tell you a little bit about ourselves. The applicant will tell you a little bit about the project. And this is really the initiation of our process. So any comments that you have tonight will certainly inform our review. We have a presentation to go over our process a little bit, and we want you to raise any questions or any initial thoughts that you have, but I would like to also make it known that because this is the beginning, there's many opportunities for comment as we proceed through the process and many opportunities to engage with the staff to ask any questions down the line, give any feedback throughout the process. And so hopefully as the presentations come forward, you'll learn a little bit more about the project and a little bit more about our agency. We encourage you to engage with the process. We have a project-specific mailing list, and so if you'd like to stay updated on project activity, we strongly encourage you to sign up for that. We also have monthly council meetings where project updates will be given to the council each month on what the current status of the project is. So if this is something that you'd like to continue to be engaged in and would like to stay up to date on, please sign up for the mailing list. Please join our monthly council meetings. And I think that concludes my remarks. I'll hand it over to our siting specialists, Maria Belkina and Lance Caputo.
Thank you, Amy. Welcome, everybody. Thank you all for coming to participate this evening. My name is Maria Belkina. I'm siting specialist for FSEC, and I would like to introduce my colleague, Lance Caputa. We will be giving a short presentation on the FSEC process for those who are unfamiliar with our agency. A little bit of the history of the FSEC agency. FSEC was created in 1970 for the siting of the thermal power plants. The intent was to create a one-stop permitting agency for large energy facilities. FSEC is comprised of state and local government members who review each application before voting to make a council recommendation to the governor. If recommending approval, the package to the governor includes a draft certification agreement or SCA, which defines all pre-construction, construction, and operation plans. If approved by the governor's office, the decision preempts other state or local regulations. FSEC is comprised of members from several different state-level agencies. The chairpersons are appointed by the governor, and there are standing members from 5 other agencies, appointed by those agencies to sit on the council. There are additional agencies that may elect to appoint a council member during the review of a new application. The local county shall also appoint a council member for the review of a new application. If a proposal project is located at the port, the port may appoint a non-voting member. Multiple energy and generation facilities fall under FSEC's jurisdiction. Some projects, such as thermal power plants greater than 350 megawatts and nuclear generation for the purpose of generating electricity, are required to be sited through FSEC, while others, such as wind, solar, green, hydrogen, storage, or clean energy manufacturing, can opt in at any size. Transmission lines greater than 115 kilovolts can also opt in, while lines greater than 500 kilovolts, alternating current, or 300 kilovolts direct current are required. Here is a map of the facilities that are certified or have applied for certification under FSEC's jurisdiction. You can see marked in green. There are 7 operating facilities, including 2 natural gas facilities, 1 nuclear facility, 2 solar facilities, and 2 wind facilities. The blue marks indicate the 4 additional facilities that are approved, but are not yet constructed. The clear circle and the 1 facility in the process of decommissioning. FSEC is currently reviewing 7 projects marked by yellow, including the Cascade Renewable transmission.
Don't be intimidated by this flowchart.
Your mic.
Thank you for reminding me. Here's a flowchart showing the general process an applicant will go through when they submit an application to FSEC. There are yellow boxes on the chart that indicate specific milestones in the process where the council and staff seek public input. You can see that there are multiple processes that happen concurrently when FSEC is reviewing an application. The permitting process outlined across the top row involves identifying and preparing applicable environmental permits. The land use and adjudicative process running through the middle in the State Environmental Policy Act, or SEPA process, is shown along the bottom. All these processes ultimately feed into the council's recommendation made to the governor, where an adjudication is required following the land use consistency hearing, which will be later tonight. An order is issued to commence proceedings and initiate the intervention. There are pre-hearing conferences through which parties are granted intervention status and issues are identified. Adjudicative hearings are then held. After this, the council looks at all the information in the adjudication record and deliberates. Finally, the council develops an order establishing their findings of fact and conclusions of law from the information provided throughout these proceedings. For every project proposed, a SEPA review is performed. When a determination of significance and a decision to prepare an environmental impact statement or an EIS is made, public comments are taken on the scope of the EIS. After public comment for scoping, the SEPA responsible official, which is the agency director, determines the scope of the EIS. A draft EIS is prepared and issued with a minimum 30-day public comment period, after which the final EIS is prepared and released. Following the conclusion of these separate avenues of application review, the council develops its recommendation to the governor, tying together the information brought forth throughout the application review process. To be considered for expedited processing, an applicant must make the request in writing. If the project meets two criteria of land use consistency and a mitigated determination of non-significance is issued, the council can grant expedited process review. In this expedited process, the adjudication step is not required and an environmental impact statement is not prepared. Applications granted for expedited processing do hold an additional public meeting prior to the council's recommendation to hear any conditions that may be considered to impose on the project. A conditional use, which is a conditional use, may be considered to impose on the project a conditional use process hearing. The council prepares a recommendation to the governor in an expedited time frame under this process. FSEC is also the issuing agency for any applicable state and local environmental permits a facility may require, including water quality and air quality permits as they may apply. The permits are identified in the final package with the council's recommendation to the governor. If an application is approved by the governor, FSEC then has oversight of the environmental compliance for the life of the facility through decommissioning. FSEC has standing contracts with applicable state agencies that assist in the monitoring and enforcement of conditions either in the site certification agreement, identified permits, the environmental impact statement, or the mitigated determination of non-significance. At the conclusion of the council's review of an application, a recommendation is made to the governor to either approve or reject the application. This initiates a 60-day window within which the governor will then either approve the application, reject the application, or remand the application back to the council for reconsideration. Any application that is rejected by the governor is a final decision on that application. As previously mentioned, FSEC oversees facilities under its jurisdiction through decommissioning. Decommissioning plans must be reviewed and approved by the council. The project must also provide financial assurance for the decommissioning in the event that the project is no longer able to complete the process. Assuming the project decommissions while still under full control of the developer, these costs would be paid by the certificate holder directly.
Also, I would like to add, our work is closely coordinated with the Oregon Department of Energy and the U.S. Army Corps of Engineers, ensuring that both states and federal agencies are aligned in the environmental and permitting review. That wraps up our presentation for this evening, and before we end, I'd like to remind everyone how they may submit the comments for this proposal. You may send in written comments by email to comments at fsec.wa.gov by postal mail to our office at listed here, 621 Woodland Square Loop, P.O. Box 43172, Olympia, Washington 98504-3172, or by phone at 3606-41345. When FSEC is in an active comment period associated with a specific milestones, comments might also be submitted to our online comment database, https://comments.fsec.wa.gov. All comments received, regardless of timing or method of delivery, will be saved with the project record and available to council and staff for review. Thank you.
Okay, thank you both. So with that, we will, as queued up, obviously move to our applicant's presentation, which we welcome. Mr. Hawker.
Thanks for coming out. Thank you to FSEC. And we'll try to make this as brief as we can. Again, my name. A little bit. Okay. Is that better? Are we all right? Okay.
Yeah, and certainly we appreciate this focus of the evening, so we'll make sure you get out. Thanks.
So I'm Chris Hawker. I'm with a company called PowerBridge. We're based in Connecticut, and PowerBridge has specialized in submarine transmission projects on the East Coast. We developed, constructed, and currently operate 2 such projects that are very comparable to the one we are proposing tonight. Before I go any further, I do want to acknowledge we're very well aware that this whole area of the Columbia River is the ancestral home of indigenous tribes. We have been, over the last few years, reaching out and continue to reach out and engage with the tribes. And I just, wanted to make sure that everyone knows that we're very well aware of the importance of the Columbia River and the surrounding area, not just to the tribes, but everybody who lives here. We might as well get started. We're going to talk about the situation currently and the need for the project as we see it. We're going to describe the method of installation, what it does, how it works, show you where it's going, and give sort of an overview of the environmental reviews and the agency processes that will determine whether this project goes forward or not. Next. We think it's important to understand, not just from our perspective, but from a regional perspective, that there is a very significant constraint on the current transmission system. If you go way further east, that system, which is primarily BPA, is not so constrained. But when you get to a point right around here or right around the Dalles, that's when the system becomes very much constrained to get it to basically where the people are, west of the Cascades. And any number of studies that indicate a tremendous additional need additional need for energy over the next 5 to 10 years. In addition, as I'm sure you're aware, both the states of Washington and Oregon passed clean energy laws. They differ slightly, but the impact is to ultimately require 100% clean energy in both states by, depending on which state, 2040 or 2045. So the dilemma is, how do we move cleaner energy from east of the Cascades when there's no transmission available to support it. Our project is designed to help meet that constraint. It is not the ultimate solution to the problem, which is much larger than what our project can provide. You can see on the screen basically what I just said. I mean, there's a number of factors pointing in the direction of moving energy consumption in this region to clean and renewable. The transmission constraints already exist between east of the Cascades and the load centers along the western part, not just Portland, I'll get into that a little bit, but all the way up and down the sort of I-5 corridor up to Seattle. It's very challenging, as I'm sure you recognize, to build new overhead transmission lines, particularly in an area as sensitive as the Columbia Gorge. So this next slide is not the easiest thing to intuitively understand, and I'll try not to belabor it, but this is kind of a depiction of the way energy flows from east of the Cascades to the west. And there are a lot of ongoing studies that indicate the kind of upgrades of the transmission system that will be needed to actually complete the process of unconstraining, unbottlenecking the transmission system. Well, for better or for worse, the transmission system is complex. It's a system. It's not just a point-to-point transmission line. So all of these, like the blue circles and the black and the red, these are all sort of proposed upgrades that would be needed in order to facilitate the removal of the constraints that exist. Our project is the green line, and the advantage there is that it moves directly from east to the west without necessitating all these other upgrades. Now, in my opinion, many of those other upgrades will probably have to be done in order to meet the demand, but ours can at least bypass having to do those upgrades and help relieve the constraints, we think, earlier than the other upgrades can be done. Next. So we're going to be talking about a solution that, in our opinion, helps meet the renewable energy goals, helps improve resiliency and safety. Obviously, an underwater transmission line does not carry the risk of wildfire or going down in bad weather and that kind of thing. It helps meet the increasing load in the west and won't interfere with river uses and other infrastructure. And can I go back to this confusing slide here? This helps answer the question, what does this do for Washington? Because clearly we're starting in the Dalles, we're ending in Portland, so this must be a strictly Oregon beneficial project. And we're just sort of asking you to let us pass through. That's not the case. And the reason is, as I tried to explain, that the real aim is to get to this north-south corridor and relieve the constraints so that power can flow better north and south, including north up to the load centers in Washington. All right. So our project is about 80 miles underwater and about 20 miles on land. It's hard to depict a 100-mile project in one slide, but this just shows a map of where it is, the green being the underwater portion, the yellow being the on-land portion. In Washington, there's really only one area where there is a land-based effect, which is about a 7-mile bypass around the Bonneville Dam. And this is a slightly easier depiction of the route in Skamania County. It lands in Stevenson. It primarily uses State Route 14 buried underground. I should emphasize that no portion of the transmission line itself will be visible. It will go around the Bonneville Dam, as you see, and re-enter the river. If you can make out, it's hard to see, but if you can make out sort of the little purple bars, the way the line is brought out of the river and back into the river is with a construction technique that's very well accepted called horizontal directional drilling, or HDD. So the entry and exit in and out of the river does not involve trenching through shoreline or any of that. In fact, the drill proceeds very, very deep from the starting point into the river. And when I say very deep, around 40 or 50 feet deep. So there's no interference with surface habitat or anything like that. Just to complete the picture, there are land routes both in the Dalles and in the Portland, it's called the Rivergate Industrial Area. So, and again, the line will be buried primarily under public rights-of-way. That does involve trenching about 4 feet in the road, very similar to what you would see for an underground power line or a pipeline, water line, any of that. Conventional construction techniques. So why underwater? It's not just because we've done underwater. It's because there are very few constructible and feasible alternatives available. And we have looked at those. And in fact, the FSEC permit application, both in Washington and in Oregon, as well as the Army Corps of Engineers permit applications, require a rigorous alternatives analysis. But very briefly, there is no available path through the gorge for an overhead transmission line. You would think, well, okay, can't you just bury it all the way in, say, I-84? And the answer is no. And the reason for that is that that kind of linear parallel utility is not allowed by either Oregon DOT or the Federal Highway Administration. And that's aside from any constructability issues, of which there are many. The same goes for many portions of State Route 14. I'm sure we've all driven it. I think we counted more than 300 obstructions, obstacles, or very, very grave engineering challenges that make an entire route along State Route 14 not constructible, not feasible. Now, the area that we're in, which is just a few miles, is pretty clear. We've been consulting with the Washington DOT, and so it can be done for short distances, but not for the length that we're talking about. Same for the railroad rights-of-way on either side of the river. If you drive along 14 and look at that railroad right-of-way, it's very, very narrow. There are bridges and obstructions. The point is, we've looked at this. And in order to help meet the transmission needs, resolve those constraints, and meet the renewable energy goals, the river is the best alternative. Next. What you're seeing here, first of all, at the table is the actual diameter of the cable that can carry 1,100 megawatts for 100 miles. The cable really involves two cables that are bundled with a fiber optic cable. That's what is shown on the left-hand photo. And as I've said, this is this is the type of project that we have successfully developed and constructed. The photo on the left is actually from our Neptune project, showing the cable bundle being paid off the end of the bottom, not the bottom, the back of a ship, a barge, and into the water, which we'll show on the next slide. How does it work? It does not involve mechanical dredging. It does not involve leaving a scar on the river bottom. What it does involve is a piece of specialized machinery that is used in various places around the world, which we have used, called a hydroplow or jet plow. The way it works is kind of depicted on the right-hand figure. A ship or barge proceeds slowly in the direction that it's going, up or down the river. The cable is on a turntable. You don't see it there, but it's a very massive turntable carrying miles of cable. It is paid off the back of the vessel as it proceeds. It is threaded through the hydroplow, which is the white thing. And at the bottom of the hydroplow is a blade, very much like a plow blade, except that it contains a number of high pressure water jets. And the water jets create a trench about 2 feet wide by essentially emulsifying the sediment. As the sediment rises within the trench, the cable is simultaneously laid into the trench to the required depth. Now, in this case, we believe the required depth, and this is a requirement of the agencies such as the Corps of Engineers, would be a minimum of 10 feet and maybe 15 feet below the sediment. What happens is that the sediment has risen up, the cable is laid down, 75, give or take, % of the sediment lays back down within the trench. So it's a simultaneous process. It moves very, very slowly. The blade is adjustable. The water pressure is adjustable. The whole thing is being monitored during installation in real time to determine where it is and how deep it is at any given point. Again, it's a proven process. We have used it ourselves. The photo on the left simply shows kind of what it looks like, and it doesn't look a whole lot different from a work barge that you might see on the river right now with a work boat or two around it. And as it moves slowly, maximum maybe 1.5 miles a day, that's what you would see. That's the only visible aspect of it. We talked about the interconnection points at Big Eddy and in Portland in the Rivergate industrial area. I had said that there was no visible part of the transmission line. The visible facilities are called converter stations. And that's a photo of one here. They are very similar, clearly, to what you would see at a substation. Their purpose is to convert the alternating current or AC power that comes in to Big Eddy, convert it to direct current or DC power in order for it to be transported efficiently for a long distance underwater. It then goes to another converter station in Portland, where it is converted back from AC to DC power. I'm sorry, DC to AC power. This particular station is in downtown San Francisco. There is a very similar project that was not done by us called the Transbay Cable that's been operating since about 2010. It laid a high voltage cable, DC cable, under San Francisco Bay. And there are two converter stations. This one is in San Francisco. The other one is very similar. It's in a town called Pittsburgh in the East Bay. This is a complex project. We know that. It involves approvals from 3 major entities. One of them is Washington FSEC. Another is Oregon FSEC, and the other is the U.S. Army Corps of Engineers, which has the control or approval process in waters of the United States. So we are in the process of submitting applications to all 3 entities. We fully expect a complete NEPA review. Hopefully the state SEPA review and the NEPA review will be handled in a coordinated process. We need all of these approvals. We can't just put the line in Skamania County and hope for the best. So that's the, as I said, it's a complex approval process that is being undertaken here. And it involves a great deal of environmental studies and description, most of which was included in the application that was submitted to state of Washington. And we fully expect that there will be follow-on questions from FSEC that we will answer. We've been trying to encourage a highly coordinated process. And you know, we think that's what it's going to be. We certainly hope so. We also need interconnection agreements with BPA and with Portland General, since Portland General owns the western interconnection point, Harborton. And as I said, there's a number of studies that we've either completed or are underway that talk about things like biological assessments, endangered species, sediment transport, which is what happens to the portion of the sediment that has risen out of the trench. How far does it go? What sort of impacts does it have? Are there contaminants in it? You know, virtually any question you can think of is going to be asked and answered. We have conducted a geophysical survey of the river bottom so that we have a pretty good idea of where the cable can go and where it can't go. Physically, there are a number of features of the river that would make it difficult, if not impossible, to employ a hydroplow. However, in the route that we have selected, we believe it is constructible based on the studies that we have done. Just to mention, several of the considerations we have employed from the beginning are to stay away from the shoreline, because that's a historically, culturally sensitive area. To stay away from sensitive habitat areas. To, as much as possible, stay away from the navigation channel. So that, and to stay away from physical constraints such as steep side slopes or rock formations or that kind of thing in the river. Where are we now? Well, as you know, we have submitted our application to Washington. We are in the process of submitting a comparable application to Oregon. Actually, the Oregon application is pretty extensive, and it's being completed and submitted. We have submitted, there's actually, when we talk about an Army Corps permit, there's actually kind of a series of permits that involve use of federal facilities, and as well as the environmental permit called Section 404. And part of that process includes extensive consultation led by the Army Corps with the federally recognized native tribes. Excuse me. So the Army Corps is conducting that. They have to as the lead agency. But as I said before, we are taking steps to directly engage with the Indian tribes, but with the full knowledge that at the end of the day, the consultation process belongs to the Army Corps, not us. Next. We do expect that there will be benefits to the communities that we pass through. We certainly know from experience that construction and installation, which should take about 3.5 years, will provide a great many construction jobs. This is primarily for the converter stations, but also in support of the in-water installation. And before I forget, the in-river installation will take place during the winter months, probably over 2 seasons, within agency-specified work windows that are designed to allow that kind of construction. And this applies to many kinds of in-water construction, not just us, to avoid spawning and migration periods and that kind of thing. So they're pretty narrow windows. We do expect that the communities that we affect, that we will be open to providing community benefits. We have in the past with our existing projects that could be just amenities to the community, could be property taxes for the on-land cable. It could take any number of forms, and we certainly don't believe that we can do this without acknowledging any impacts that might take place. Similarly, we fully expect that there will be a mitigation program primarily associated with cultural considerations in the river, and are engaging with the tribes, again, through the Corps or in partnership with the Corps to flesh those out. There's kind of a side benefit, which is that if in fact, right now, significant renewable energy east of the Cascades, there's no point in building it because you can't get it to where the power is needed. So hopefully this project, along with others, will help open up those pathways to go east to west and allow those planned and intended solar, wind, battery storage, that kind of project to go forward. And of course, those are all subject to their own permitting requirements and all the rest of it. But to the extent they go forward, those will also provide community benefits to those communities, construction jobs, that kind of thing. So with that, it is a team that is helping to develop this project. PowerBridge is the lead developer. One of our partners is NextEra Energy, which is a major utility and renewable energy provider in the U.S. It's publicly held. We have some NextEra folks here. And they are the ones that currently own and operate the the Transbay cable under San Francisco Bay that I talked about before. So with that, I think I'll mention, because some of these You know what? Let's go to the slide. There we go. Just to quickly describe our experience, the Neptune project was completed in 2007. It provides 25% average of all of the electricity used on Long Island. So it's a very, very significant contributor to Long Island. It runs about 24/7. It runs probably 95, 98% of the time, and has run successfully for 18 years. The Hudson project came a little later, completed in 2013, so it's only 12 years old, and it links the power grids in New Jersey and New York. It was installed in the Hudson River under a permitting process that is very similar to what we're describing here, where you had both states, New York and New Jersey, and the Army Corps of Engineers come together in a coordinated fashion to go through the studies and the requirements and finally issue approvals. So with that, and I think I should mention, I checked that this slide presentation is available, I believe, and if it isn't, it will be online through the FSEC website. So if I went through it too fast, which I probably did, and you want to go look at it again and then send questions to us, there's a website, Cascade Renewable. Did I get that right? Yeah, cascaderenewable.com, where there's a mechanism that you can ask questions, and please do. We want to be open, we want to be transparent. As I keep saying, we've done this before and understand how important it is for people to understand what the process is, how it works, what the impacts are and are not. And you know, we want to, you know, provide whatever information we can to answer questions. And with that, thank you.
Thank you very much, Mr. Hawker. Appreciate that overview. And let me try to just get my camera on for folks when kind of going to each next section for our online audience. So with this, we are going to move into public comment. And generally, we operate on a 3 minutes per person basis. We appreciate your understanding and respect to that. Certainly, we try to make sure there's enough time for everybody. And if you have questions, you're welcome to submit them, including here tonight before the mic. Know that this isn't necessarily by design to be, you know, answering all those questions tonight. If I think that we have time and there's an ability to answer kind of, you know, the quicker questions or just capture opportunity in the moment, I certainly as chair support that. Perhaps that's something that we might consider at the end after we finished questions and comments for the record. Again, the purpose of this is to help inform what the FSEC staff, as well as the council, who ultimately you know, sits as a body and oversees what should go into a site certificate agreement and whether or not there should be one. So that's not obviously a given. But ultimately your input tonight and throughout the process, but this is the beginning. And so you have questions or comments that should be considered throughout. That's why we're here tonight for this portion. The next portion that we'll speak to in a little more detail, again, is specific to land use and how that relates to land use here in Klickitat County and other lands. There'll be a short presentation on the specific slice of the project within this particular county. So with that context, Ms. Grantham will help me call on those who have already signed up. And if you have not, you certainly are welcome to comment tonight. If you want to sign up, I believe in the back, there's also a box for written comments, in addition to the other means, both online and email, phone, mail, etc. And if, once we get through the initial list, you know, if you've changed your mind or a thought came and you want to raise your hand, I'll certainly call on you. When you come forward, if you just state your name clearly for the record, but actually if you do, our staff who ultimately maintain this record, please spell your name for them. We'd certainly appreciate that. And then we will start the clock after that introduction and spelling of your name. So you'll have a full 3 minutes for your comments. With that, Ms. Grantham.
Certainly, Chair. The first person I have signed up is Fred Grief.
Thank you for this opportunity. Did you say you want me to spell my name?
I think if you signed in, you're probably okay, but could you help us, or if someone can come forward and help with the mic if need be?
I might have turned it off.
Well, I think maybe you just have to get a little closer.
And this is Ms. Grantham. I can confirm that we already have Fred's name spelling, so he can go on with
So you can
his
just
comment.
proceed. You've pre-signed up, so you're.
So you
good to go.
have the spelling for my name.
You do not. Just, you may begin when you're ready there.
Okay. One thing I would like to say is that there was very little public notice of these meetings. And there's very few people commenting because nobody knew about this and nobody's here. And that was the same thing in Stevenson. And it is a little curious to me that there's no meetings in Oregon or Portland or anyway. I assume that this is going to be an EIS. Can't imagine it wouldn't be with the significance of this project. But I do have a few suggestions for the SEPA responsible official at FSEC before they, to be sure that they make that determination. And I think I'll have a lot more input once the scoping starts. But so SEPA, Washington State SEPA Rule 197.11.0800, incomplete or unavailable information. There's a whole lot of that associated with this proposal. And agencies shall obtain, when there's information on significant adverse impacts, essential to a reasoned choice among alternatives is not, when that information is not known, and the costs are not exorbitant, agencies shall include the information in their environmental documents. Now, if the impacts are unknown and they don't choose to spend the money, then they have to assume worst case possible impacts in those cases. And so the EIS definitely has to look at all the worst case impacts. But again, this may be more related to the scoping, which comes next, but that's a very important part of SEPA analysis. And you must, so impacts that are unknown but possibly very significant, those really do have to be looked at as worst case. Another thing on the SEPA, on the threshold determination of significance or non-significance, significant, so under SEPA, significant adverse impacts in one location may not be the same as in another location. And Power Bridge talked about Neptune and Hudson projects in New York, in Long Island, in New Jersey, Hudson River. That is so different than what we have here. We have a world-class area that still has wild fish and so much beauty and majesty here that the health of the fish, there's trees are gone in Long Island, and the whales were gone early with the whaling in Connecticut. We have issues here that are just completely 100% night and day different that really do have to be carefully looked at here, because we still have a very precious land with values that should not be allowed to have further cumulative adverse impacts to the fish here.
And Mr. Curry, I'd appreciate if you could try and wrap up your comments. I
Okay.
allowed some extra time for you last night, and I
Right,
appreciate you
okay.
being here tonight. But
Well, I'm just gonna drop it at that. There are some significant impacts here that have to be addressed, and I hope that the determination of significance is made with this proposal.
thank you.
Next speaker is Amber Carter.
Thank you, Mr. Chairman and members of the council. My name is Amber Carter, spelled A-M-B-E-R, Carter, C-A-R-T-E-R, and I'm here on behalf of the Columbia River Steamship Operators Association. We're here to express concerns regarding the proposed transmission line that involves multiple crossings through the Columbia River Federal Navigation Channel. This critical waterway is essential to our regional economy and to our members who depend on its uninterrupted, safe, and efficient operation. Our members include ship owners, operators, agents, launch service, towing and bunkering, as well as facilities and ports along the river system. The Columbia River Trade Corridor is the lifeblood of our regional economy and facilitates the movement of over 51 million metric tons of cargo at a value of over $25.3 billion in 2023 dollars and supports over 40,000 local jobs. Disruption to the navigability of this important waterway could result in substantial economic and operational consequences, especially for industries reliant on this cost-effective transportation route. Our concerns include transmission line depth and dredging, the lack of risk assessment and mitigation planning. And we are also troubled by the lack of public engagement with Maritime during the project planning stages. We have submitted written comments that expand on these points further, but to conclude, we respectfully ask that FSEC require additional information in its project review on how Cascade Renewable Transmission plans to mitigate these operational and safety challenges. Thank you.
Thank you.
Next speaker is Dave Berger.
Hi, my ears plugged, so if I'm too loud or too soft, let me know, okay? Okay, so regarding this project, I work with engineering students for a long time, and we're doing a project in Africa on trying to provide safe drinking water to villages and their people living in huts and thatched roof houses. And so my thinking was, wow, let's put in a treatment system, because that was what I was taught to do. But instead, my students said, hey, let's change the roof and get cleaner water off the roof, and whatever treatment we do will be a lot better. So when I look at this and I think, oh, we're going to take all this solar energy and put it in eastern Washington and eastern Oregon and transport with a big power line underground to Portland, my head scratches and I go, why don't put the panels on the roofs in Portland? So an alternative that should be looked at, and I know EISs look at even the no action alternative, should be the action alternative of putting in solar panels all over Vancouver and Portland, if that's the intent to get solar energy to those people. And it might create a hell of a lot more jobs and be a lot cheaper. Okay, so that's one thought. The other thought is this really about getting solar energy to people, or is it about getting it to data centers and people, you know, big investors with AI? So that's sort of a question that comes in my mind. Now, having spent a lot of time working on river water quality, another issue that comes up to me is, of course, re-entrainment. And there's a lot of stuff down in that river, and the river is different from place to place, and there's a lot of toxics, and that stuff needs to be looked at really closely. And on top of that, we're having tremendous problems in the river that are impacting Native American fishermen with algae and with toxic algae now all over. I've sampled for toxic algae in 4 places, and every place I sampled, I found it. So how is all this upheaval going to affect nutrients and going to affect water quality in the future. And once you bring it up, it comes down and it flows all the way to the ocean. So all this stuff isn't going to happen in one place. It's a dynamic system. You're affecting the largest break on the West Coast that for the Pacific Ocean between San Francisco Bay and Puget Sound. So it's really a critical thing to look at the ecosystem in a very deep way. And I want to thank you for the time.
Thank you.
Next person is Deanna Chase.
It's really tall. Oh,
I think
now I broke it. Can I just hold it? Okay.
so.
Well, it's Dina. It's just Dina. Dina Chase. Simple. Sounds fancy when you say it. But, Osio and Wado Gadugi, welcome to our land. My concern is your lack of native people here. You say that you're working with native tribes, the Corps of Engineers, you know, they're a federal agency. They're not a sovereign nation. You have an obligation to sovereign nations. There are 4 River Treaty tribes. There are several tribes that are historically recognized that you are obligated to work with, and not just consult. They are the consultants. So that is my concern, that there are no native, I don't know, raise your hand if you're native. Are there any native tribes here? No, okay, so, and while I'm a Cherokee citizen, I do work with an ally with a lot of the 4 River Treaty tribes here. I'm appalled that there are no representation of native tribes here. So that is my biggest concern. These waters that you say, they're sacred. Water, air, you want to put this transmission line through a sacred place. There's nothing more sacred than water. There's nothing more sacred than water. Water is life. The air we breathe, that doesn't just mean tribal people. That means you. That means your family. That means your next generations. We're talking about all of our granddaughters and grandsons that will have to live with this. And we're already recovering from tons of environmental mishaps that have happened in the name of progress. I just think I'm going to stop there. Consult your tribes, your sovereign nations. The Army Corps of Engineers is not a sovereign nation. They work for and with sovereign nations. You need tribal leadership here before you make another move. I think that's where I'll finish.
Thank you.
Next I have is Mitch Patton. Mitch Patton, I see that you're online. You're up next. Chair, would you like me to move on to the next person?
Can you hear me? Can you hear me now?
Yes, we can.
Okay. Yeah, my mic wasn't turning on. Yeah, this is Mitch Patton. I just found out today about this meeting and the other meetings that were held, so it's kind of hard to put anything really basically together other than the fact that getting the information out to the public seems to be a big failure at this point. I'm on the RAB board at Bradford Island as well. And that's one of our biggest failures that we have there is getting the community involved or getting the community the information that they need to know with what's going on at that Superfund site. And now we have this submarine line going in on the bottom of the river, and it's inside the NSA. There's multiple things wrong with this whole transmission line that's wanting to go in the river. The bottom we know is contaminated. We've known that for years. and sending the submarine line down the bottom of that to disturb it just seems like really reckless and danger to me to do something like that. And I am going to submit written public comment, but I thought I would at least get the time to say that we, the public, need to know more about what's going on with this thing. Um, it seems like it's kind of coming through pretty quickly with very little public input being said on it. And again, the tribes need to, I mean, they have a lot to say about this. And I think we need more information from them. And the other thing that kind of popped into my mind was we have some representatives, like Skamania County has a representative, and I don't know if Clark County does or Klickitat County does, but I'm wondering why those representatives didn't maybe make a little more effort in getting that information out to the public that these meetings were going to be held. So we kind of need to work on that as well, and that kind of falls back onto the whole thing of getting the information out to people. Just it's a failure. Whatever you're doing is not working, and I'm going to probably step aside right now with that because there's so many questions that are unanswered. I guess the other thing is that I fear mostly is if we do the written comment, which basically sometimes goes to a dead end street, some of the council will read it, but the rest of the public can't read that public comment. As our county commissioners did, they changed the written comment from the meeting packets to you have to do a public records request now to receive any written public comment. And I really truly hope that isn't the case with what you guys have going on here, because you can't make a public records request on information that you don't know is out there. So hopefully you'll be transparent with the public comments and let all of the public see it. And like I said, I will do my written public comment, and hopefully the rest of the public will be able to see it. So thank you for your time.
Thank you. And given a process question, let me, as was also posted in the chat, thank you, Ms. Grantham. The comments do go to the public website. They are public facing, so please know that when you submit them, both they'll be out there, and if that gives you any concern, then know that they will be out there. So, Ms. Grantham.
Thank you, Chair. The next person I have is Nathan Baker.
Good evening, Chair Beckett and members of the council. I'm Nathan Baker, Senior Staff Attorney with Friends of the Columbia Gorge, and I will be focusing tonight on two procedural issues with this hearing. These issues will be familiar to you because I brought them up each night, but this is a separate hearing in a different county, so I must raise these issues again. The first issue is that this hearing is premature. The duty to conduct an informational public hearing is triggered by, quote, the receipt of an application for site certification, end quote. That's RCW 80.50.090 subsection 1. FSEC has not yet received an application. It has only received a draft application, and draft applications don't count. Last night at the Skamania County Land Use Consistency hearing, the applicant's attorney, Mr. McMahon, conceded that the document submitted is only a draft application. He then declined to explain why they only submitted a draft application, specifically whether they submitted a draft application by mistake or whether this was deliberate. Perhaps, for example, if they were trying to obtain a specific vesting date for land use consistency purposes. I suppose I agree with Mr. McMahon. The reason or reasons why the applicant submitted a mere draft application don't matter. But I do find it a bit odd that the applicant is very deliberately withholding an explanation about why they have pursued this course of conduct. At any rate, regardless of the motivation, the legal result is the same. FSEC's required procedures are not triggered and cannot be triggered by draft applications. Thus, this hearing tonight and all other hearings this week are premature. If and when an actual non-draft application is submitted, that will trigger the need to hold the hearings required by the plain language of the statute. The second issue involves council membership. For tonight's hearings, the membership of the council must include a member appointed by Klickitat County. Contrary to what the applicant's attorney said at last night's land use hearing, the council plays no role in that appointment and there is no discretion involved. Rather, the statute says that the Klickitat County Commissioners, quote, shall appoint, end quote, a voting member of the council. And that person, quote, shall sit with the council, end quote, for both hearings tonight. During FSEC's monthly meeting earlier today, FSEC officials confirmed that Klickitat County has not yet made an appointment to that council, and for that matter, neither has Clark County nor the cities of North Bonneville and Stevenson. In fact, it appears that FSEC has not even yet invited these local governments about the need to make their appointments. Instead, FSEC staff have only stated that these governments received notifications about the hearings and about the fact that the draft application was received. Holding this hearing without the participation of a council member appointed by Klickitat County violates the statute. In conclusion, if and when the applicant submits a non-draft final application, FSEC will then need to schedule informational public hearings in each of the 3 counties, and the Klickitat County appointee to the council will need to sit with the council for the Klickitat County informational and land use consistency public hearings. Thank you very much.
Thank you.
The next speaker I have is Eric Riston.
Thank you and good evening, Council. My name is Eric Riston. I am an attorney at Cragg Law Center. I am here representing Columbia Riverkeeper. I just want to quickly emphasize that Columbia Riverkeeper shares and adopts the procedural issues that Friends of the Gorge has raised tonight and in the prior informational meetings. Those include both the objection to starting this process on the submission of a draft application as opposed to a complete application like the statute requires, as well as the lack of local appointees to the council in all of these hearings. And I want to elaborate just a little bit on the draft application issue, because it's not just some technical legal issue that we're raising, it's a real problem. The draft application that was submitted is missing a remarkable amount of the information that's required to be in an application by Washington Administrative Code, Chapter 463-60. For example, the applicant is supposed to include detailed fish and wildlife and habitat surveys in the application, but we don't have anything even resembling that for the in-river portions of this project. No surveys, mapping, or description of the habitat characteristics of the parts of the river this project will run through. Likewise, they're supposed to include detailed information on soils and topography, but as the applicant has admitted last night, soil studies are something they're still planning on doing but have not done yet. The list goes on, and Riverkeeper will be submitting a separate letter regarding all of the ways that this application is incomplete. But the bottom line here is that there are serious public process issues with moving forward with the application at this time. The public has a right to comment on an application that is at least substantially complete. The draft application that has been submitted is far from that, and the draft application makes full participation in this process impossible. Thank you for the opportunity to speak tonight.
Thank you.
Chair, this concludes the list of people that I have.
So I'll turn it on, but I don't want to blow people's ears out here. Thank you. Are there other members of the public here who wish to speak? I see a hand with the white hat first, and then I'm sorry, ma'am. We'll take you next. Again, please come forward. And
Tom Wishard, W-I-S-H-A-R-D, with Local 701 Operating Engineers, on behalf of just under 4,000 members. We're for this project. With the trades, we all have the state-of-the-art facilities, and you'll get the best of the best. Thank you much.
Thank you. And if, ma'am, over next, welcome.
My name is Kalama Reuter. I live in White Salmon, and I wanted to.
Could you spell your name, please?
K-A-L-A-M-A, first name, last name Reuter, R-E-U-T-E-R.
Thank you.
And I wanted to ask a question. I heard 2 depths that the cable would go. First, I heard 40 feet. It would be deep, deep. Then when the hydro thingy-majiggy was doing its thing, it sounded like it would be 10 to 15 feet deep. This is a big river. 10 or 15 feet of a plowed up area might not stay covered. It's a moving, this is a massive being who's moving, and I have concerns about that. The other thing that I noticed, and I do take notes, but I can't get everything, that it looked like there's an expedited way that you can avoid an environmental impact statement. In my limited understanding of being at various hearings, the scoping comes with the environmental impact. I'm not sure, but if you do the expedited thing, you cut that out. It was sort of there in the fine print over on the side. No environmental impact statement needed. So I have big concerns about that. Thank you.
Thank you. And I do see a couple other hands. Again, process question, let me just quickly speak to it. The FSEC presentation just noted that that is one of the processes. Which process will be determined has not even remotely been decided, including, as was noted earlier, scoping is to come and things like that. So it does exist, but it doesn't mean that that's what will be used here. So next hand, please come forward. Thank you.
Hi, I'm Jennifer Decent, and that's D-E-C-E-N-T. I'm with LIUNA Local 335. We are the laborers, if you don't know what LIUNA stands for. For increased economic development and opportunities, we need more transmission lines and resilience. As laborers, we live and work in these communities. So we care about the environmental impact to our beautiful backyard. So when I read about the process of burying the line having minimal impact to the riverbed, as it is buried in silt, which recovers quickly, that seemed to be an environmentally friendly alternative to me. As Washingtonians, we have very high standards, and I realize this is in the very beginning of the process. So I look forward to the following this project and its process. Thank you for your time.
Thank you. Any others in the room tonight who would speak? Please. And then I'll make one last call for that. Please come forward. And I was just going to let our online audience know if there's anyone else who wishes to speak, if you'd please raise your hand online. And then soon we will conclude this portion of the meeting and move to our land use consistency. But please.
Thank you. I'm Roger Nichols, R-O-D-G-E-R-N-I-C-H-O-L-S. And as a member working with Goldendale licensed radio station, I was surprised. The only way I found out about this was because I had a Google alert set on my Google. And that's how I found out about this yesterday. I was able to get a little bit on the radio station today, this afternoon, but it's kind of late in the process. So if you're going to have meetings that take place in a county, you want to have all the media involved. I also work with the Goldendale Sentinel, and I really appreciate, I'll be doing a story about this, but I would be really appreciating if we had more notice on this, and I'm taking notice of all the comments as well this evening. I also want to suggest that there's an agency you've not talked about yet, and that's the Columbia River Gorge Commission. You have two sections of the proposed line that are not going to be in the water, that are going to be on the ground. They're going to disturb the ground, and they are in the National Scenic Area. At least part of the station near Big Eddy will not be inside the Dallas City boundary. And also the loop that goes around in Skamania County will be on. And the Columbia River Gorge Commission will be as a land use agency, and those approvals will be needed as well. So you might want to put that on your chart. Thank you.
Thank you very much. Any last hands in the room? Okay, we'll proceed. Any hands online? Ms. Grantham, I don't see any, but okay. Then I will call this opening hearing to conclusion at 7:12 p.m. And we will move into our land use consistency hearing. And let me provide just a brief word, and soon Judge Miko will join us, and he will further explain this. So again, during this hearing, we'll have testimony regarding the proposed project's consistency and compliance with land use plans and zoning ordinance. That's the only subject that will be allowed during this hearing. And this is very specifically in order for the council to create the record and make a determination on land use consistency and compliance with local land use plans and zoning ordinances. So with that, Judge Miko, if you would please join us officially, and know you've been here throughout, and please share your opening comments as you intended, and thank you for your support of this process.
Good evening, everybody. I'm Administrative Law Judge Russ Miko with the Office of Administrative Hearings. And I'm here to help facilitate the public comment portion of the land use consistency hearing. So after the applicant has presented their case and the council have asked any questions that they had, there'll be an opportunity for the public to ask their questions. But or not ask your questions, but make your comments. And there are a few things that everybody needs to know before we begin. Unlike the earlier public comment period, here we're only taking comments about whether the site is or is not consistent with and is or is not in compliance with applicable land use plans and zoning ordinances. So please make sure to keep your comments focused on those 2 points. The public comments will be limited to 3 minutes per person. I'll try not to stop you mid-sentence, but if you go over time, we might have to move on to the next speaker if there are a number still to go. So please make sure that you say your name when you approach the podium. And again, asking questions is not procedurally allowed during this comment period. So your comments may prompt the need for answers, but the purpose of this hearing is to only allow comment on the issues of consistency and compliance with applicable land use plans and zoning ordinances. Following the end of the land use consistency hearing, my job is to draft an order, including findings of facts, appropriate portions of the relevant law or code, and conclusions of law regarding whether a proposed site is consistent and in compliance with those applicable land use plans and zoning ordinances under Revised Code of Washington 80.50.090, paragraph 2, and chapter 463-26 of the Washington Administrative Code. Once I've finished drafting my proposed order, I will send that to the FSEC assigned Assistant Attorney General with the Washington State Attorney General's Office, and to the FSEC staff for any revisions prior to FSEC staff presenting the order to the council with a recommendation of adoption at an open meeting. So after the final presentations have been made and the council have asked their questions, I'll be coming back on board. So thank you.
Thank you, Your Honor, and I'm sorry I queued you up a little earlier than we had discussed. Just with people transitioning here in the room, I thought it was probably best if everyone heard exactly what you had to say so they could consider how they wanted to participate, nonetheless would have the benefit of the insight. Relatedly, and given kind of the week and the evening, also, can we please call the roll of the FSEC Council just to confirm for the record that we have a proper quorum in place? Thank you, Ms. Grantham.
Certainly, Chair, no problem at all. Department of Commerce. Excuse. Department of Ecology.
Blake Nelson, present.
Department of Fish and Wildlife.
Nate Pamplin, participating remotely.
Department of Natural Resources.
Maverick Ryan, present.
Utilities and Transportation Commission.
Brian Ryberg, present virtually.
Assistant Attorney General John Thompson.
I am present online.
Administrative Law Judge Russell Mikow.
Present and online.
Council staff Sonia Bumpus.
Present and online.
Amy Hofkemeyer.
Present.
Lance Caputo.
Present.
Carl Halapa. He is present tonight. I think he just stepped away. Maria Belkina
Present.
and Lisa McLean.
It's an online.
And do we have anyone present still for the Council for the Environment?
Yuri Kroll, present online.
Chair, there is a quorum.
Thank you. So I will turn this to our applicant team for their presentation. This will give a little further insight, obviously, on the specifics here in Klickitat County. Council members, if you do have questions about the presentation that, in this case, you've not seen yet, certainly we'll take those after the presentation, and then we will move into the public comment, and our judge will run that portion of the meeting. So over to you. Thank you.
All right, thank you. Good evening, everyone. My name is Malia Bassett. I'm an environmental planner on the applicant's team, and I am going to go over the land uses in the project within Klickitat County and Washington. So you saw this earlier. This is the entire proposed project, and tonight's focus will be on the in-water portion, since there's no on-land portions in Klickitat. So between, there's no close-up of the portion in Klickitat, but it's before the center yellow line that's past the Bonneville Dam. And I'll go through those more specifically now. So just in summary, the in-water alignment in Washington in Klickitat County has 6 segments in it, and that totals about 6 miles. When I say segments, I'm referring to the portion of the line when it weaves in and out of Washington and Oregon, and the border is the center of the Columbia River. Segments that come into Washington and then leave, so that would be one segment. Going from west to east, the numbers you see on the screen are river miles, and that's just a way for us to identify where we're at in the river. So the proposed line is the red dash, and then the highlighted portions are the portions that are in Washington State. And the series of slides are showing what's in Klickitat County border. So looking at the first segment, it's going from about I cannot see that great, 168.5 to 169.5 before it goes back into Oregon. And then shortly after that, coming back out into Washington, out of the Oregon side, not out of the water. Washington, and then going till about 172.75. Continuing east, we have a small segment around 177, and then another small segment around 179, and one. Sure, that's fun. Thanks. I know how to turn it. Oh, there we go. Okay, no, not working. It's okay, I'm almost done, sorry. That's what the numbers are for. So small segment 179, and then another segment at 180.5. And then lastly, this segment between 186.5 all the way through 187.5. And then, as I mentioned earlier, the components on land, there are no components on land in Klickitat. These are the components on land in Skamania County, City of Stevenson, and North Bonneville, which we covered in other hearings. And that concludes my side of the presentation. Colleague Emily, the applicant's counsel, is online and will give a brief summary of land use consistency.
Thank you. Good evening, Your Honor, FSEC council members and FSEC staff. My name is Emily Schimmelfennig. I am an attorney at Stoll Reeves LLP, and my firm represents the applicant in this proceeding. As you have heard this evening, the land use consistency hearing's purpose is to determine whether the project is consistent and in compliance with local land use plans, and zoning ordinances. FSEC makes this determination. The relevant inquiry for FSEC's initial land use analysis is whether the pertinent local land use provisions prohibit the proposed project expressly or by operation clearly, convincingly, and unequivocally. If a proposed project can be permitted either outright or conditionally, it is consistent and in compliance with the local land use provisions for the purposes of RCW 8050-92. As you have heard tonight, all of the portions of the Cascade Renewable Transmission Project proposed in Klickitat County are underwater in the bed of the Columbia River. There is no development proposed on land. Neither the county's zoning code nor the county's comprehensive plan impose land use restrictions on in-water uses or river bottom land within the Columbia River. In fact, Klickitat County does not even assign a zoning designation to the Columbia River. In essence, nothing in the comprehensive land use plan and in the zoning ordinance prohibit the project. Now I'd like to turn briefly to the Shoreline Management Act. FSEC's review does not consider all local land use provisions. Under RCW 8050-2018, a land use plan means a comprehensive plan or land use element thereof adopted by a unit of local government pursuant to chapters RCW chapters 3563, 35A 63, 3670, or 3670A. Similarly, a zoning ordinance under RCW 8050-2030 is an ordinance of a unit of local government regulating the use of land and adopted pursuant to those same chapters. Importantly, the Shoreline Management Act is found in RCW chapters 9058, which is not one of the provisions I listed in the definition of land use plan or zoning ordinance. The applicant understands the need for review and compliance with the Shoreline Management Act, and it is for FSEC to conduct this review. To my knowledge, the most recent precedent here was the Columbia Solar Project in Klickitat County. In that case, the Shoreline Management Act review was not conducted during the land use consistency hearing and was instead considered at a later date. However, ultimately, whether that analysis is done now or later is a matter for FSEC in its discretion. Finally, I'd like to request that the record remain open for written comment for 21 days. Thank you.
Thank you. And I believe that concludes the presentation, just to confirm. Okay, members of the FSEC Project Council, if you have questions for the presenters, let me ask that now. Council Ryan.
Thank you, Chair Beckett. Less for the presenters, but more just as a point of inquiry, and I know that this was briefly raised in the land use hearing last night. Is there a point in the administrative record where the in-water portions of the river are going to be evaluated for land use consistency? I think that this could be me being naive about my own agency, but within the state of Washington, DNR is required by statute to evaluate uses of in-water portions of navigable waters. So I'm curious if that will be included in the record at some point.
And I don't know if at the applicant table or if Council Thompson or staff would wish to weigh in. Looking to council or staff.
Sorry,
I'm sorry.
This is Emily Schmolfenig again. Just to briefly address that, you are correct that at some point during this process, the analysis of land use consistency through DNR will have to be completed. Here, FSEC is just looking at local land use jurisdictions, so the Klickitat County, the county that we're in. And that's why, here, we concluded that there's kind of nothing in the Klickitat County comprehensive land use plan and zoning ordinance that prohibit the project. But of course, the DNR side of it will have to be analyzed at a later date.
Did any other staff or council wish to add to that? Seeing none. Council Ryan, does that cover your question for now?
Thank you, Chair.
Thank you. Other council members, any questions? Okay, then I will conclude the presentation portion and council questions, and we will move this to Judge Miko and our public testimony portion.
Okay, thank you, everyone. As a reminder, 3 minutes per comment, and please keep your comments focused on whether the proposed sites are consistent and in compliance with applicable land use plans and zoning ordinances. Ms. Grantham, would you please call the first speaker?
Certainly. The first speaker is Nathan Baker.
Good evening, Chair Beckett, Judge Mikow, members of the council. My name is Nathan Baker. I'm with Friends of the Columbia Gorge. First, we incorporate the objections that we made at the hearings the last 2 nights, objecting to the multiple procedural errors in this process so far. These errors are violating the appearance of fairness doctrine and the due process rights of stakeholders. And I will expand on a couple of those issues tonight. As you heard in the last hearing, this hearing is premature. Only a draft application has been submitted, and draft applications do not and cannot trigger FSEC's required processes. And with land use consistency, vesting concerns are implicated. So once a non-draft application is submitted, FSEC will need to schedule land use consistency hearings on the application. The second issue is that there is no Klickitat County appointed council member at this hearing. The statute says that Klickitat County shall appoint a member of the council, and that person shall sit on the council for the land use hearing tonight. The statute requires that. It is error to hold this hearing tonight without the participation of that required member of the council. Next, regarding certificates of land use consistency, at last night's land use hearing, the applicant's attorney brought that issue up. He said or implied there had been extensive dialogue between the applicant's team and the various local governments. But then we later learned last night that the applicant did not even ask any of the local governments for such certificates until Monday of this week. No such certificates have been presented to the council, and now it is too late. The council's rules only contemplate an applicant entering such certificates as exhibits, quote, at the land use hearing, end quote. And this has to happen at the hearing to allow anyone present at the hearing to rebut any certificate. Mr. McMahon last night also misstated the effect of a certificate of consistency. He said, if one is submitted, quote, the inquiry ends there, end quote. That is not true. Instead, the council's rules say that if an applicant submits a certificate of consistency, that shifts the burden from the applicant to anyone present at the hearing who opposes such a certificate. But again, if any of this happens, it must happen at the hearing. Next, we have concerns about the ridiculously short written comment period of only 6.5 hours and the extremely short notice period of only 13 days for tonight's hearing. The public is getting less notice that would be guaranteed for any project, even small projects, anywhere else in the state of Washington. And there's no reason to rush. This hearing tonight doesn't have to be held at any particular time. And so there's no reason to schedule it. The agency should not have rushed into this hearing. Finally, on the substance, the Columbia River matters for land use purposes. The land underneath the river is submerged land, and it is also riverbed. And in both of those senses, it is land. Because this project would involve land use and development activities underneath the Columbia River, FSEC's land use inquiry must include the Columbia River. And in the Columbia River, the National Scenic Area rules prohibit new transmission facilities. We've explained all this in great detail in our written comments, and following me will be Steve McCoy explaining further. Thank you very much. It's been a great week.
Thank you very much for your comments. Ms. Grantham, would you please call the next speaker?
Next I have is Steve McCoy.
Good evening, councilors. I am Steve McCoy. I'm a staff attorney with Friends of the Columbia Gorge. Thank you for this opportunity to comment. The majority of this project is proposed within the Columbia River Gorge National Scenic Area. The National Scenic Area was
sir, can you please slow down just a little bit for our court reporter who's requesting that, and we'll give a little additional time here for the relaying this. Thank you.
Okay, gotcha. Should I start over or?
Why don't we just start from the top?
Okay. Good evening, councilors. I am Steve McCoy. I'm a staff attorney for Friends of the Columbia Gorge. Thank you for the opportunity to testify tonight. The majority of this project is proposed within the Columbia River Gorge National Scenic Area. The National Scenic Area was created by Congress in 1986 by a federal law, the Columbia River Gorge National Scenic Area Act. There is also a bi-state compact, the Columbia River Gorge Compact, which is a compact between the states of Washington and Oregon, with pre-consent from Congress in the National Scenic Area Act. Thus, the compact is the joint product of three sovereigns, the federal government and two states. There is a management plan adopted by the Columbia River Gorge Commission and the U.S. Forest Service, which contains the rules and regulations for land use and development activities in the National Scenic Area. Most of the counties in the National Scenic Area have adopted their own National Scenic Area land use ordinances pursuant to the National Scenic Area Act. These ordinances must be consistent with the Gorge Management Plan. Klickitat County has not adopted a National Scenic Area ordinance, and as a result, the Gorge Commission is the permitting entity for land use and development activities in the Klickitat County portion of the National Scenic Area. Because this project is proposed in Klickitat County in the National Scenic Area, it requires a permit from the Gorge Commission approved under Gorge Commission land use rules. The project also needs a permit from the U.S. Forest Service. It's called a Federal Consistency Determination and is pursuant to Section 14D of the National Scenic Area Act. It is required for two reasons. The project is proposed on federal land, U.S. Army Corps of Engineers, and the project requires multiple federal permits from the U.S. Army Corps of Engineers. For both reasons, there is a federal nexus that triggers the need for a National Scenic Area permit from the Forest Service. In Table 2-4 of the draft application, it acknowledges the need for a Forest Service permit, but the draft application fails to acknowledge the need for a Gorge Commission permit. During the hearings this week, the applicant has displayed a PowerPoint slide with a list of needed permits. The applicant's list conspicuously omits the Forest Service permit, even though it is listed in Table 2-4 in the draft application. And in neither document does the applicant acknowledge the need for the Gorge Commission permit. Make no mistake, this project cannot go forward without permits from both the Gorge Commission and Forest Service. As Friends explains in detail in our written comments, the portions of this project proposed in and underneath the Columbia River and in the Columbia River Gorge National Scenic Area that outside the designated urban areas are prohibited. Furthermore, Gorge Commission Rule 350-082-0040 states that review and approval are required. For the stretches of the Columbia River located in the National Scenic Area portion of Klickitat County, but outside the urban areas, the National Scenic Area rules do not list any category of uses under which this project might qualify. Therefore, the project is prohibited under Gorge Commission Rule 250-082-0040. That result is confirmed by the 1995 Gorge Commission appellate opinion called Nature Friends Northwest, which we've cited in our written comments. I also want to note that there are several savings clauses in the National Scenic Area Act that create exceptions for certain water-based uses, including transportation on the Columbia River, fishing, and water rights. So Congress was clearly intending to include the Columbia River in the Act. It also carves out an exception for existing transmission facilities owned by Bonneville Power, so Congress intended it to apply to other utility facilities. These provisions further demonstrate that Congress intended permitting to be necessary in the Columbia River. In conclusion, the entire project needs a permit from the U.S. Forest Service. The Klickitat County portions of the project need a permit from the Gorge Commission, and the project is prohibited by the National Scenic Area rules in the Columbia River outside the urban areas. Thank you for this opportunity to comment.
Thank you very much for that. Ms. Grantham, would you please call the next speaker?
The next person I have is Elaine Harvey.
Good evening. Judge. My name is Elaine Harvey. I am from the Comithal Band of the Columbia River. I am a resident of Klickitat County. I come from a tribal fishing family on the Columbia River. We fish in Klickitat County and Skamania County annually. We depend on the Columbia River for subsistence and ceremonial purposes. This project is inconsistent with our treaty
Your Honor,
fishing
we're
rights
being
on the
asked
Columbia
for,
River.
the court reporter can't keep up, Your Honor. I'm sorry to have to relay this to you again, but ma'am, could you please, I'll leave this to the judge to handle from here.
Okay, thank you. Yes, if you could please just speak a little slower so that our court reporter can make sure to accurately capture everything that's being said. Thank you very much.
Okay, thanks. I really tried to talk slow. Okay, I'll start over again. My name is Elaine Harvey. My Indian name is Wanaknai. I come from the Cometpo band of the Columbia River. I reside in Klickitat County. I come from a tribal fishing family on the Columbia River who fish in Klickitat County, Amania County and the shores, but also on Oregon sites. This project is inconsistent with our 1855 treaty rights on the Columbia River. We have fishing sites that have been passed down generationally for thousands of years. This project has potential to impact our traditional fishing and also our fishery resources in the Columbia River, such as salmon, sturgeon, smelt, lamprey. And there are many tribal fishermen who are concerned with this project. I just want to state this statement that this is the first of its kind in the Columbia River, and also that this project is on a riverscape, not a landscape. And you have a potential to detrimentally impact our fishing and our way of life. Thank you.
Thank you very much for your comment. Ms. Grantham, will you please call the next one? Next speaker?
Next person is Eric Riston.
Thank you, and hello again, Council. My name is Eric Riston. I am an attorney at Cragg Law Center here on behalf of Columbia Riverkeeper. I am again here to express that Riverkeeper shares and adopts the procedural concerns raised by Friends of the Columbia Gorge tonight and at the prior hearings, including objecting to this process moving forward before there is an application, the lack of local government presence on the council, and the misinterpretations made regarding the deadline and effect for the consistency certifications. And I want to echo some of the points that I made in the informational hearing regarding the impossibility of adequate engagement here and the flaws in the draft application. The application's discussion of land use consistency is cursory, and there are not even detailed maps to demonstrate the exact boundaries of the site. This clearly violates Washington Administrative Code 463-60. 362, which requires that detailed information on land and shoreline use. I believe, for example, the maps that we saw in the presentation from the applicant were not included in the application. That makes it remarkably hard to participate in this as members of the public, especially when you consider the 10 days of notice we were given for this hearing and the 6.5-hour comment window we were given for written comments. All this goes to say the same point I made in that initial public information session. This draft application is simply not ready to move forward yet, and doing so is both violating many of FSEC's rules and prohibiting the public from being able to effectively engage in this process. Finally, I just want to address an argument made by the applicant about not needing to consider the county's shoreline master plan. This is incorrect. If you look at the council's recent order from February 2025, this year in the GoldenEye battery storage project, you'll see FSEC has considered shoreline master programs at this stage, and that's the correct decision. It's required by the statute. It's right that the Shoreline Master Act or Planning Act is not explicitly listed in those definitions, but the county shoreline master plan is adopted pursuant to both the Planning Enabling Act, RCW 3670, and the Growth Management Act, RCW 3670A, which explicitly incorporates shoreline plans into the statute. And both of those statutes are listed in the definition of land use plans and zoning ordinances, which is why they're required to be considered. Thank you.
Thank you very much for your comments. Ms. Grantham, will you please call the next person?
The next person is Mitch Patton.
Can you hear me okay?
Yes, I can. Thank you.
Okay, great. Hey, I'll try to do my best on this. It's a little out of my league right now. But my concerns are the National Scenic Area Act, or the National Scenic Act, plus the National Scenic Area itself, and then the Shoreline Management Act. It doesn't seem to like this project is following any of that stuff at all, or if it's even able to move forward with that. And then after just hearing briefly a little while ago about, I don't know if it was the Dalles or Klickitat County, but somebody doesn't even have an ordinance for land use because it's inside the river area. Well, this to me seems that this project should be stopped immediately, and each county and city, municipality, or whatever it is up and down that Columbia River needs to throw a moratorium out until we can further assure that all the public safety and wildlife and everything is being followed. Because it kind of seems like to me is what's going on here is this project is being railroaded to get through, because I think if I remember correctly, with some moratoriums that the county actually in placed in Skamania County, was some people were allowed to move forward because they had an application in already. Well, from what I'm understanding right now, that application isn't been submitted. It's in a rough draft. So if it's in a rough draft, then it needs to be, we really need to step back and take a further look at this thing because of the things that I brought up, the Shoreline Management Act, the National Scenic Area, the National Scenic Act. There's quite a few federally laws that are in place that do not allow, that point blank do not allow this to happen, but yet it continues to move forward. And it's unfortunate that the public is just now finding out, and these 6-day and 13-day windows for public comment is ridiculous. So hopefully we can do a better job at trying to get the information out to people and make sure that the people who's ever overseeing this, these oversight committees or whatever it is, are following these federal laws and state laws and the Shoreline Management Act and the Wild Species Act, which is in the Columbia River. You have all that fish and everything that's in that river that's protected by federal law. And none of it's really, I don't feel, is being addressed. So on that, like I said, I will try to do another written public comment as well to try to get my points across, and hopefully somebody is out there's listening. And I will be contacting the commissioner's offices and the planning department's community development to ask for a moratorium to be placed in Skamania County. And yeah, thank you for your time, and I hope that makes sense.
Thank you very much for your comments. Ms. Grantham, will you please call the next person?
The final person that I have as a sign up is Elijah Citas.
Good evening, counselors and Your Honor. Thank you for the opportunity to comment. My name is Elijah Citas. I am an energy policy analyst and attorney with Columbia River Intertribal Fish Commission. I want to first incorporate the comments made by Elaine Harvey tonight, and incorporate them as under CRIPFIC comments. It was not CRIPFIC's intent to participate during this portion of the proceeding, but as I commented last night, given the speed of these decisions, and given the short window of the public comment period for land use consistency, we've decided to comment tonight. And I want to just comment to raise two primary considerations for the record for what is not consistent with the project's application and the zoning. This portion of the Columbia River falls within Zone 6 of the Columbia River, which is set aside to uphold the treaties of 1855, which the 4 Lower River Treaty Tribes each entered into with the federal government to reserve their fishing rights on the Columbia River. This portion of the river is a tribal treaty fishery. It is regulated as such by the tribal governments, and it is held, that right is held in trust by the federal government. This portion of the river also includes in the Klickitat County at least 16 treaty fishing sites. These are sites created by 2 acts of Congress, one in 1945 and another in 1988. They're codified at 25 CFR 247 and 248. The in lieu and treaty fishing access sites were set aside for the continual and exclusive use of Columbia River tribal fishers to continue their time immemorial and treaty reserved rights to fish in the Columbia River. And I just want to repeat that because, again, the reason we decided to provide this on the record is that this was totally absent from the applicant's proposal and absent from the discussion during the general overview of the project. And it bears directly on the land use consistency. As Ms. Harvey mentioned, this is a first of its kind project. And as another commenter mentioned, the river zoning and the uses of the river, the uses that are both state protected and federally protected and tribally and federally regulated, are important for understanding the compatibility of this project. And as this project is proposed to run through the middle of this fishery, it is incompatible with those uses and those zonings for the river. So I just want to conclude there and just reiterate the significance of this particular stretch of river. There are impacts throughout the river, but again, we wanted to comment during this land use consistency period because we cannot underscore how significant Zone 6 is. This stretch of river, these fishing sites that are right here in Klickitat and Skamania County. Thank you so much.
Thank you for your comment. Ms. Grantham, are there any other people signed up to speak?
There are not.
Okay. Well, then I will turn it back over to Chair Beckett. Thank you.
Thank you, Your Honor. I don't see any other activities I think we need. Council, any other comments, closing comments? Council Pamplin.
Thank you, Mr. Chair. Really appreciate FSEC staff here hosting these 3 meetings this week. Been very informative. Certainly hearing a lot of substance comments about this project. That's going to be very helpful and informative as we launch into this review. I've also heard a number of process concerns, and Mr. Chair or Director Bumpus, I don't want to put either of you on the spot here, but I also want to flag that we heard on Monday during the land use consistency hearing, a member of the public requested additional 30 days for the public comment period. I believe this afternoon, if I heard correctly, the applicant representative requested the public comment period be extended 21 days. And I don't know if there's an opportunity, Mr. Chair, to consider that this evening, or perhaps as a council, we can discuss that in the future, a near future here. But just wanted to raise that was something that's on my mind and has been very consistent over the past 3 days from a process concern. Thank you.
Yes, no, thank you for speaking to certainly a key point, if not an obvious one at this juncture that we've all heard and participated in. So I can certainly assure you, I think on behalf of both staff and council, that all that input, including how the comment periods were structured, which ultimately are tied to each meeting to the degree that can reside in a larger single bucket, if you will, of comments, is certainly, I think, something that will be determined in the very near term, but I am not prepared to act on that myself tonight as chair. I acknowledge that is an aspect of what you're asking, but let's make sure that whatever evolution occurs here based on the current record that is now in place, the record will continue. So I just want to make sure that we ensure that the next step is clear and then lasting going forward. Certainly there will be multiple comment periods throughout this, and certainly I think we need to do our best to make sure that, as required in many cases, those multiple layers of comments are as clear and preferably consistent as possible. Because there's so many different jurisdictions and requirements involved, if anything, we may be in a position where inevitably the comment periods become a bit confusing in their multitude. So that is part of what we're working through, and I believe certainly we will have this as a council discussion in the near future as well. So with that, if there's other comments from council, would welcome them, and if not, well, let me just pause and ask. So, council members, any other comments, or including anything that you wish to share in response to mine?
No, thank you, Mr. Chair. I appreciate that. It sounds like we'll have a future opportunity here to discuss the public comment periods, even associated with the meetings this week. Thank you.
Thank you. Councilor Barrick.
Thanks, Mr. Chairman. I just wanted to echo the thanks for the additional context there and the additional information around the continued process in this case, but really wanted to just take the time to thank everybody for their participation in this. As you've noted many times and has been noted during this, it's so important to get information from the public and comment from the public, and we've heard some great information here. Just want to thank everybody for taking the time and getting in front of a bunch of people and providing that comment. It's a very important part of the process. So thank you.
Thank you. Other comments from the council? Okay. Well, with that, I will then conclude tonight's second hearing. It is 7:55 p.m. and we are adjourned.